Good afternoon, everyone. My name is John Gielow, and I'm the CEO and Executive Director of Legal Aid Chicago. Welcome to our fourth annual webinar series called Legal Aid Matters. Today is our first session of this year's series, and today's session is captioned Family Preservation in the Face of DCFS Intervention. Before we get started, a couple of administrative details you should be aware of. First, please sign in with the link found in the chat to obtain CLE credit and to give a course evaluation. The link will be posted throughout the presentation, and the CLE code will be given at some point during the presentation. Please fill out the evaluation as well at the end. We value your feedback. Second, if you have any questions or comments during the presentation, please use the Q&A function at the bottom of your screen. We'll address as many questions as time permits directly following the session. So those questions will be held until the end of the session. Third, we will be recording the session and all future sessions so that we can make them available to those unable to attend. The recordings will be made available at the end of the series. Now to get started, it's my pleasure to introduce our panelists. First, my colleague, Melissa Staas, who's a supervisory attorney with our Children and Families Practice Group here. She joined us in 2018 after practicing public interest law for 10 years with the Family Defense Center, where she practiced and represented hundreds of parents involved in the child welfare system through direct services during an investigation. She represented folks in DCFS administrative proceedings and juvenile court dependency proceedings. She did appellate advocacy and did affirmative class action and federal civil rights litigation. Here she represents our clients in a variety of matters impacting families, including child welfare, orders of protection, divorces, and parenting allocation cases. Angelina Smith is an attorney with Jenner & Block. As the pro bono partnership lawyer in the firm's pro bono department, she coordinates and manages the pro bono client partnership program that has grown and become tremendously popular with the firm's clients. Pro bono partnerships help to highlight the true alignment of values and service between Jenner clients and the firm to the benefit of those who are in need of access to justice. Previously, Angelina was a work equity lawyer in the talent and development department of Jenner, where she ensured that work was equitably staffed among junior associates and that they were helped in gaining opportunities to develop their skill sets. And Delaney Gielow joined us, Legal Aid Chicago, in 2020 as a Skadden Fellow with a project focused on ensuring that DCFS was held accountable to its statutory mandate to make reasonable efforts to prevent removal of children from their parents and to reunify families that have been separated. I'm now pleased to say she's now a staff attorney in our Children Families Practice Group, where she continues to represent parents and caregivers involved with the child welfare system for reasons related to poverty, domestic violence, and other circumstances beyond our clients' control. So thanks for joining us, Melissa. Now I'm going to turn it over to you.
Thanks so much. I'm glad so many people were able to join us today, and I'm really pleased to have the opportunity to describe the ways in which our clients experience DCFS intervention and also the legal representation we provide to keep families together when it's safe to do so. So when we're talking about the child protection system, it's referring to a web of statutes, rules, regulations, procedures, and courts and customs that have developed over time pursuant to federal funding requirements. And ostensibly, the purpose of this system is to protect children from severe abuse. But in reality, what we see is that the resources of the system are largely used to regulate family life based on claims of neglect that stem oftentimes from circumstances that are beyond their control. And I'm going to be talking about that, and that'll be a theme that recurs throughout our presentation. So in Illinois, there are two tracks that can occur in tandem. The first one is an administrative process of investigation, and that's triggered every single time there's a hotline call made alleging abuse or neglect. And then a second track is a judicial process. And this is utilized in a much smaller percentage of cases, But it's usually triggered when children are formally removed from their homes. And this is just to give people a little bit of a visualization of how these cases proceed, so you have a sort of frame of reference as we talk about some of the issues. So every case begins with a hotline call and then a DCFS investigation, and that's that top track. At the end of each investigation, there's a decision to either unfound, meaning no credible evidence, or indicate the report, meaning that they are substantiating it. Just to give a little bit of a data point, in the fiscal year 2022, there were a little over 90,000 hotline calls and investigations. And this was an upward trend, and this is within Illinois. What's interesting is that it does contrast with national data that was released by the Administration for Children and Families, showing that nationwide hotline calls have actually hit a 5-year low. But for whatever reason, in Illinois, we're experiencing a spike. Of those 90,000 calls, only about 21,000 or 23% resulted in an indicated finding. So that means that the system is spending a huge amount of resources investigating and regulating families where it ultimately concludes that there's no credible evidence of abuse or neglect. And then for the bottom track of the cases that are called into the hotline, a very small percentage get funneled into juvenile court. So every case is going to have a top track, and then a small percentage will have both tracks. Usually juvenile court is triggered by the taking of protective custody, meaning removing children from their parents and placing them in foster care, which can and often does constitute kinship care, meaning keeping kids with relatives. Even though it is a small percentage of the overall cases that are called into the hotline, we need to remember that there are 80 to 90,000 hotline calls every year. So that means that thousands of kids in Illinois are being taken and placed into foster care on an annual basis. And in Cook County alone, the average annual number is about 1,300. Just a quick overview of what the legal process looks like. There's an initial hearing within 48 hours of taking protective custody, where the court needs to make certain findings for the case to continue and for the kids to remain out of the home of their parents. And the judge almost always makes those findings at the initial hearing. That's a finding of probable cause and that there's urgent and immediate necessity. Once that initial hearing is over, and in almost every single case, that initial hearing is going to end with the children remaining outside of the home. The case is set for adjudication, which is the trial where the state has to prove its petition by a preponderance of the evidence. And then shortly after that, a dispositional hearing, assuming the state has met its burden. What are we going to do with the family moving forward? In Cook County, the average time between that first initial hearing and the dispositional hearing is a year or more. And as I mentioned, very, very few families experience reunification pre-adjudication. So children are remaining out of the home for that entire time until the dispositional hearing. And then that dispositional order is the first time that any party can appeal as of right. And I'm just going to plant a marker there mentally, because I'm going to come back to that in a little bit. Post-dispositional hearing, cases can linger for additional years before a family is either reunited or the parental rights are terminated, which is often referred to as the death penalty of family law, because it is a permanent and virtually irreversible finding. There is also the option of guardianship, although that's utilized not as frequently as either reunification or termination. So the importance of having a family preservation approach, which is what we take in our office and in our practice. First, there are long-standing, well-established constitutional protections that shield family life. The United States Supreme Court jurisprudence going back decades and decades establishes a fundamental liberty interest under the 14th Amendment to a parent's right in the care and custody of their children, and also to family integrity, which arguably is also a constitutional right that the children have. And this is particularly important to keep these constitutional predicates in mind when we're looking at the reality of the types of cases the state is actually investigating and pursuing. 70% of the hotline calls are regarding claims of neglect, not serious abuse. And of the 23% of hotline calls that result in an indicated finding, an even smaller percentage are indicated for claims of serious abuse, such as physical harm or sexual abuse. Similarly, if the cases where protective custody is taken and a case is brought to juvenile court, the lion's share of those cases are alleging a risk of harm, not actual harm. And the final thing to keep in mind is that intervention into family life, when it involves separating children from their homes and their parents, comes with a huge price for the kids. Social science research is definitive that separation from families causes lifelong negative impacts for children. So with that sort of introduction and setting of the table, I'm going to hand off to Angelina from Jenner & Block, who's going to describe a case that we've been working on together.
Thanks, Melissa. Let's consider a case study here where the importance of the family preservation approach would have been a benefit. We could take, for instance, a case where Jenner and Legal Aid Chicago co-counseled on, and as a disclaimer, the names, ages, genders, and the like have been changed to keep anonymity. This is a case of a single mother here, Jennifer, visiting Illinois with her son, Michael, on spring break. Both are residents of another state, but their story of family separation begins with the mother, Jennifer, seeking medical attention and ends in separation from her young child, Michael, who is thrusted into the DCFS system. The key facts of this case are as follows. Jennifer and Michael are visiting Illinois. Jennifer suffers a health crisis and goes to the hospital and takes Michael with her, and she's seeking medical attention for herself. During her time in the emergency room, Jennifer was looking for ways to ensure that Michael would be cared for as she followed the recommendation of the doctors to be admitted. She was presented with the option of Safe Families Program, which is an option for temporary support through DCFS, but was told that there was no Safe Families immediately available at the time. So without a viable Safe Families option, Jennifer continued to reach out to family members out of state and was able to have her mother arrive in Illinois the very next day. However, by this time, DCFS took protective custody of Michael, and on the same day that Jennifer was discharged from the hospital, which was 2 days later, DCFS filed a petition for adjudication of wardship on the basis of neglect. Now, the basis of this neglect here was for the fact that Jennifer sought medical attention without a plan to care for Michael. Initially, Jennifer was awarded the statutory minimum of 1 supervised visit per week, which was often canceled and very sporadic. Officials in the process also failed to properly communicate with Jennifer about her son and the requirements to reunification. A few months after the separation, where DCFS was awarded temporary custody of Michael, Jennifer was able to retain pro bono counsel. Now, within a few weeks of retaining counsel, Jennifer regained consistent in-person visits with Michael and the goal of beginning the road to reunification. Jennifer's team then files a motion to vacate the temporary custody order and was successful. Overall, in this case, Jennifer was separated from Michael for a period of 5 months.
So when we're talking about how the child protection system interacts with families, it's really important that we keep in mind the fact that the system does not treat people fairly. And there are some systems of oppression at play here. The first that we see, and that is very common in investigations and in cases that go to juvenile court, is classism. We see in our office on a regular basis that DCFS is coming into contact with our clients for reasons that are directly connected with our clients' financial circumstances. One example is an accusation of inadequate supervision when after-school care falls through, or when a child needs to stay home sick and the parent can't miss work. And even more tellingly, we know that almost all the families that enter the juvenile court system are poor, because almost all of them qualify for an appointed attorney. We also see that due to female-headed households and the feminization of poverty, the majority of parents engaged in the child welfare system are mothers. A blatant sign of how the system operates under a sexist paradigm that we see is the way in which domestic violence is often used as a predicate for DCFS intervention. And with the problem being that there's virtually no differentiation in how the system is treating alleged abusers and the survivors. In our office, about half of our cases have DV, domestic violence, as an operative factor to DCFS involvement. And in almost all of those cases, DCFS never disputes that our client was the victim survivor. As for cases that are screened into juvenile court, looking at a 6-month period of data revealed that domestic violence was explicitly pled in the state's petitions in about a quarter of those cases. Finally, the system is not only anti-racist, it's not even race neutral. And it is undeniable that across the country, Black families are investigated and separated at a rate that far exceeds their proportional representation in the general population. And just to highlight that reality a little bit more distinctly, so this is data that was developed by the Children and Family Research Center, and it is an annual study of racial disaggregation data that they are going to be providing on an annual basis. And this shows that in Illinois, this recent data confirms that the disturbing reality of a racist child welfare system is alive and well. And what I think is telling about this, these two images is that the disproportionality exists at sort of a shocking degree, where Black children and Black families are represented at least twice double their representation in the general population, so a racial disproportionality index of 2 or more. But also that disproportionality grows as each level of state intervention increases. More Black families are brought into the system, and then they are treated more harshly. So the gross unfairness of the system with all of these systems of oppression is itself a telltale sign that the way the state is regulating and interfering with families is not being limited to only those cases of severe abuse and harm. This is a theme that I've mentioned at the top, but the unacceptable inequities in the system really come into stark relief when we then go back and talk about the trauma that kids experience due to separation, because it tells us something about which children do we value and which don't, and which kids are more vulnerable to this sort of harm. So this is a quote by the American Academy of Pediatrics, and it was in response to the 2018 border separations. Separating children from their parents contradicts everything we stand for as pediatricians. Moving ahead, in fact, highly stressful experiences like family separation can cause irreparable harm, disrupting a child's brain architecture and affecting his or her short and long-term health. This type of prolonged exposure to serious stress can carry lifelong consequences for children. And again, when we're talking about visiting the harm of separation on children, it really must be viewed as the most extreme of remedies that we take in only the most extreme of cases. But unfortunately, that's simply not the reality for the families that we're representing, or for many of the Illinois families that encounter the child protection system. Connecting back to a point I raised at the beginning about the length of time these cases can linger in the system, I want to briefly address some of the trends we see as to why that prolonged duration might occur. Now, in some cases, perhaps even in many cases, the delay can be attributed to, in part, a parent disengaging or not doing the services DCFS has set forth. We sometimes see our clients becoming discouraged and disconnecting from services and then reconnecting, and it's not always a linear path. But often that disengagement never occurs in a vacuum. And often there are a lot of structural elements that are converging to adversely impact how the case is proceeding and then how a parent is feeling about the system that's being imposed on them. And so I'm just going to walk briefly through these barriers that we've sort of identified: bureaucracy, devaluation of family relationships, a family's financial resources, a paternalistic lens, and inadequate legal remedies. So in terms of the bureaucracy, this can mean a lot of things, especially when we're talking about the child welfare system. So the ways in which we see the slow pace of bureaucracy impact a family are where a caseworker and sometimes judges are prioritizing checklists and customs and practices over an individual assessment of what each family's particular circumstances and needs might be. There's a strong culture in juvenile court of this is how we do things. These are the steps we take. And I am thinking of a current case that we just had in court and mediation last week, where the caseworker agrees that there are absolutely no safety concerns about the teenage kids having unsupervised time with our client, who is their mom. But the agency won't approve those unsupervised visits because the case hasn't been open long enough. That was the rationale that was given. We also see huge delays by the department in making referrals to services that they're going to require parents to begin. So that slows the entire case down. And also there's a congestion on the court's calendar. So it's hard to get cases up in front of the judge to have the judge really looking at, well, are the steps DCFS is taking, is this necessary? Can we move things along more quickly? And the final bureaucratic barrier that we see parents experience is limited resources for parent representation. Research by the American Bar Association demonstrates very clearly that when parents have robust legal representation, the outcomes for kids are improved dramatically, both in the type of outcome, meaning the rate of reunification is increased, and duration, meaning cases are remaining in the system for a shorter period of time. We have a terrific civil division at the public defender's office, but they have only 1 or 2 attorneys assigned to each courtroom, which means they are juggling upwards of 100 cases. And it simply isn't sufficient resources to provide the sort of representation parents need. And I've talked a little bit about how the system really does not value the family relationships because it doesn't give due regard to the harm that is caused by separating kids. And we also see this in the way legal representation for the minor children is handled. There is no statutory right to legal counsel for kids who have juvenile court cases. In Cook County, we happen to have a hybrid model where there is an attorney appointed to represent the child, but that attorney also serves as an appointed guardian ad litem who is representing the best interests of the child. And it's not uncommon for these 2 roles to come into conflict when the child is saying they want to go home, but the appointed attorney has made a best interest determination that they don't think it's in their best interest, which is often the status quo. Cases come in with that sort of presumption imbued in them, even if it's not supported by the law, but that's often how the posture in which the cases begin. And in terms of a family's financial resources, obviously these can serve as a contributing reason into why families come into contact to begin with, but a family's limited resources often prolongs the amount of time a case remains pending in court once the children have been removed. It's extremely stressful to be poor and to not have adequate resources, and this stress is compounded for the parents who are scrambling to do everything they can to reunite with their kids and trying to meet requirements and service obligations and visitation, but also then trying to earn enough money so that they can afford a place to rent, so that they have a place for the kids to come home to. And we see cases regularly where a parent's participation in services is impaired by transportation issues, or where visits can't proceed to unsupervised overnights only because the parent isn't financially able to afford their own apartment. A paternalistic lens is a little bit more of an esoteric barrier as compared to some of the other ones, but I think it's an important one to mention because it does emanate from the doctrine of parens patriae, which is the foundation of the entire child protection system. And this is the principle that the state's judgment should substitute for that of a citizen. As a result of this doctrine, every single step of the process is imbued with a paternalistic approach. And it really elevates the expertise of the judge, the caseworker, the state's attorney, the guardian ad litem over that of the parent. It's very common for this sort of approach to manifest as tension or hostility or personality disputes between the caseworker and the parent. And this can be disastrous because the path of any given case often hinges very, very directly on the recommendations of the caseworker. I also think that the permeation of paternalism throughout the entire case is one of the reasons parents tend to disengage. It's very demoralizing to be constantly treated as though you are the person who knows the least about your own child. And the feeling of not being valued or respected is a huge reason parents disengage from the case. And then finally, we'd be able to combat a lot of these earlier barriers if we had adequate legal remedies in the law. But unfortunately, there are some structural constraints that prevent us from really moving cases along the way we'd like. I want to just revisit that marker I set down earlier, where I talked about how the first chance for appellate court review is after the dispositional finding. So that means that there are these findings that are made by the court at the very first court date at that initial hearing. And then a year or more can go by with those kids remaining out of the home and there is no appellate right. There's no right to have those initial judicial findings subject to appellate review. In addition, there's no statutory requirement for the judge or the state's attorney or DCFS to consider the harm of separation when they're making the decision to remove or keep children out of the home. And finally, I mean, there are many ways in which the legal remedies aren't sufficient, but one final way I'll note here is that there's a codification in the Juvenile Court Act of the separation of powers, meaning that judges are limited pursuant to the terms of the Juvenile Court Act in what they can and can't require DCFS to do to reunite families. So the current state of this legal framework that undergirds the child protection system just isn't designed to support families or foster reunification in a way that really honors and values the families that it's interacting with. So we're going to put the link for the CLE into the chat, and we'll mention this code at the end as well, but you might want to jot it down, 23SJ05. And I'm going to pass things back off to Angelina, and she's going to talk more about Jennifer's case and how some of these themes played out.
Thanks, Melissa. So we're going to talk about some of the strategies that the pro bono team employed in this case study. Number one was co-counseling with Legal Aid Chicago. Again, Melissa Staas and her team provided great insight into the DCFS process and knowledge of the Juvenile Justice and Child Protection Division. And as you will hear later on in this program about pro bono opportunities, Legal Aid Chicago can be a very valuable resource in navigating a family separation case. The next strategy was to establish and increase communication with all parties involved in this particular case. So one of the first instrumental acts that the pro bono team pursued, aside from noticing their appearance, was to establish a line of communication with all the parties and especially with the caseworker. The team understood that establishing a line of communication from the onset would lead to understanding the position of DCFS and what obstacles needed to be overcome to move the process along and march toward reunification. It was also very helpful for the team to be in communication with attorneys from the state and from the Public Guardian's Office to show their commitment to the case and to the well-being of Michael. This was also key in establishing trust in this process. Another strategy was to increase in-person visits. When the team started, it was understood that visits were inconsistent, they were sporadic, and it was helpful to maintain the process of reunification if we could increase and make sure that those visits were consistent. Initially, Jennifer was given in-person visits once a week and they were supervised, but they were very inconsistent and subject to the caseworker's availability. When the pro bono team advised the court of the inconsistent visits and the inconsistent schedule, the court required missed visits to be made up speedily and to maintain a consistent schedule going forward. And the last strategy that was employed, and again, at this juncture, I would like to recognize the Jennifer Pro Bono team led by Melissa Root and Kevin McCall for their skillful advocacy in this case, because when the team entered the case, temporary custody was already given over Michael to DCFS, and he was already in foster care for a few months. It was imperative that the team acted swiftly to file the motion to vacate the temporary custody order and to restore custody to Jennifer. The team argued that there was no immediate and urgent necessity for Michael to remain in foster care when his loving mother had been out of the hospital, living independently, and in a stable environment. It was also the opinion of the DCFS caseworker that Jennifer was an exemplary mother and that this particular case should not have ended up with DCFS. However, as Melissa mentioned earlier about the barriers to reunification, checklists and customs and practices was indeed a barrier here. However, the court agreed and the pro bono team's argument, with the pro bono team's argument, and after 5 months of being separated, Jennifer was reunited with Michael. So we're going to talk about a few of the takeaways, the key takeaways that the team noticed. First and foremost, to remain focused on the harm that is being done, which is family separation. From the onset, one of the reasons the lawyers on this pro bono team decided to take this case was because of the compelling human aspect, some of them being parents themselves, but it was a recognition that separation of a parent and a child is one of the most difficult experiences, and then compounded with the circumstance in this case, separation occurring out of a health crisis, something that couldn't be avoided. Sometimes in all of the litigating and processes, it can get lost that there is a child on the other end that is suffering from the loss of their parent, which could cause irreparable harm and trauma. The second takeaway was to stay in contact with the caseworker and the office of the public guardian. They are the ones that ultimately sway the direction of the case, since they have the most visibility to both the parent and the child. And we are aware that DCFS caseworkers are faced with heavy caseloads, but it was important to make sure that we had an open channel of communication with them. The team was always relaying the importance of reunification in this case, and that Jennifer was willing, ready, and able to rightfully resume her duties as Michael's caregiver. It was also important to remain in contact with the Office of the Public Guardian and to ensure they have remained focused on Michael's well-being and the harm that the separation was causing. Another key takeaway was to be an advocate for your client in all aspects of the process. Here, the team quickly realized that not only were we the legal representatives for Jennifer, but in this traumatic experience, we had to advocate for Jennifer's voice to be heard, advocate for her to regain consistent in-person visits, and at times we had to advocate for the services that she should have been getting while going through this process with DCFS. Remember, Jennifer was visiting the state of Illinois. This was not home. So now she had to remain in the state to be near to her son, Michael. And last but not least, which is in my wheelhouse here, pro bono work in this area is so invaluable. Identifying that there's a great need in this area is half the battle. We quickly noticed that the concerns of our client were readily addressed once they had pro bono counsel. So if a lack of expertise in this area causes you to shy away from pro bono work, Legal Aid Chicago can offer guidance. Lastly, as attorneys, we have this great privilege to use our legal skills in a way that serves others. And this was a truly rewarding and fulfilling experience to be able to help another family in their moment of need.
Thanks so much, Angelina. And it's really been an honor to work with the Jenner and Block team. They have they litigate, as many law firms do, that when they take on a pro bono case, they litigate with all of the resources that they can bring to bear for a paying client. So I think there have been no less than 6 or 7 attorneys at Jenner and Block who have been working on this one case. And it shows the impact that robust legal representation can have for a parent. So just in terms of how does Jennifer's case compare to other cases that we see entering the system and juvenile court specifically, it's fairly typical in terms of the type of case that triggers an intrusive DCFS intervention, in terms of there was never any actual harm to Michael, but just a nebulous concern about risk of harm. And that is extremely common in cases where DCFS is intervening. The other similarity is that throughout the entire case, Jennifer's top concern was her son, Michael, and she was really consumed by stress and worry over what this process and what this experience was going to mean for him. And we see that with our clients all the time. These are parents who deeply love their kids and who are really concerned about how this process is impacting them. It is uncommon that the separation lasted just or only 5 months. I'm using quotation marks around those qualifiers because, of course, 5 months to a child is a lifetime. But in terms as compared to how other cases, especially in Cook County, unfold, 5 months, that's the speed of light in terms of getting a kid home after he's been removed. I'm going to now kick it over to my colleague Delaney, and she's going to talk about some of the work we do to try and prevent cases from getting screened into juvenile court. Oh, and before, sorry, Delaney, I think that unfortunately, attendees aren't having access to the chat, so we will send out an email to everyone that will include the link for the CLE. But it will not include the code, but we'll put that code up again at the end so that you can write it down. Thanks.
Thanks. So I think, as Melissa and Angelina's presentation illustrates, the harms associated with family separation are profound, they're difficult to quantify, and in many cases, family separation is just not necessary. In Jennifer's case, there was no urgent and immediate danger to Michael's well-being that warranted removing him from his mom for 5 months. But the system defaulted to separation anyway, and it put this family through months of unnecessary trauma that is going to take years to fully heal from. So for the remainder of the presentation, we wanted to highlight the work that Legal Aid Chicago does on the front end to prevent family separations from occurring in the first place. This is one area where an ounce of prevention is truly worth 1,000 pounds of cure. So on the next slide, we have a visual depiction of the spectrum of types of legal advocacy that support child and family well-being. This graphic was put together by Casey Family Programs. And you'll see on the rightmost side, we have post-petition legal representation, which is the type of representation that Jenner and Legal Aid Chicago provided in Jennifer's case after a petition had been filed in juvenile court and Michael had been removed from his mom and placed in foster care. But if you move leftward, you'll see we go further upstream prior to removal. And I want to focus in particular on preventive legal advocacy, which is at the top there, and then pre-petition representation, which is just a notch over on the right. So preventive legal advocacy, what is that? Well, it is what it sounds like. It is legal advocacy aimed at supporting families and promoting the social determinants of health by addressing upstream legal issues that, if left unresolved, could lead to unnecessary child welfare hotline calls or family separations. So we're talking about advocacy to address food insecurity, preserving sources of income, protecting against wrongful denials of government benefits, fighting evictions or foreclosures that threaten to make a family homeless, addressing educational needs on behalf of kids, ensuring their schools are providing the services that kids need to thrive, and securing protections from intimate partner violence. These are all forms of preventive legal advocacy. They stabilize a family and ideally prevent a hotline call from ever being made in the first place. And this is the type of stuff that Legal Aid Chicago does every single day across our 6 practice groups. I'm sure that most people doing this work probably don't think about it in terms of like the number of hotline calls prevented or family separations avoided, but that is what it is. Because when you provide civil legal services to families that preserve their economic stability and their personal safety, that is one fewer family that's at risk of a harmful child welfare intervention. So that's why civil legal services are so vital. Now, what about cases where a hotline call has been made? So that is when pre-petition legal advocacy becomes incredibly important. Pre-petition advocacy is the term we use to refer to legal services that we provide after a family has come to DCFS attention, but before any petition alleging abuse or neglect has been filed into court. So frequently, clients will contact us after a hotline call has been made and their family is actively under investigation. The DCFS investigator will be gathering information and trying to assess whether there is a safety risk that they believe is sufficient to warrant taking protective custody of a child and filing a petition in juvenile court. Another common scenario is that a parent or caregiver will contact us after they've received notice from DCFS that they have been indicated for abuse or neglect. That means that DCFS has made an administrative determination that abuse or neglect has occurred, and they have placed that parent or caregiver's name on the state central register, which is a database maintained in Springfield of everyone who has been deemed by DCFS to have perpetrated abuse or neglect. And as Melissa explained earlier on, that process is separate from the judicial process that gets triggered when DCFS removes a child from the home and puts them in foster care. You can be indicated by DCFS for things that don't remotely rise to the level necessary to justify going to court and placing a child in care. But an indicated finding, having your name on that state central register, can have serious implications for a family. First and foremost, it can create barriers to employment. If you apply to work at a school or at a daycare or in certain types of healthcare jobs, employers will run a background check against the state central register, and then an indicated finding can preclude you from getting those types of jobs. A lot of our clients work in daycares or as home health aides, so indicated findings can be a career-ending catastrophe that will jeopardize the parents' ability to provide financially for their kids and put them at even further risk of DCFS intervention for reasons related to poverty. An indicated finding can also have other collateral consequences. It acts as a sort of red flag on someone's background. So if there are future hotline calls, that parent is at greater risk of more indicated findings and of having their children removed from their care in the future. So Legal Aid Chicago's child welfare team provides pre-petition representation to families in these types of situations. And in doing that, our primary goal is to prevent unnecessary and traumatic separation of children from their parents, particularly when poverty-related issues and factors that are fundamentally outside of a parent's control are being conflated with neglect. So things like domestic violence by a client against an intimate partner, or lack of stable housing, poor housing conditions, lack of resources to secure childcare. These are things that place families at risk of DCFS intervention, and they are outside of the parent or caregiver's control. In doing our pre-petition work, we rely heavily on our interdisciplinary model. We work closely with Legal Aid Chicago's social workers to help our clients navigate these complex systems and secure resources that will stabilize their families. We also work collaboratively with our other practice groups, such as housing, public benefits, to really help our clients resolve civil legal problems that are posing a threat to their family's stability. So just to sort of give you a sense of how this pre-petition legal advocacy plays out in practice, I want to summarize some real examples of cases that we have handled recently. So we have a client who I'm going to call Caitlin. She is the mom of 2 boys. She was assaulted by the father of her kids. She called the police, and the police, upon learning that Caitlin's kids had been in the home at the time of the assault, called DCFS. DCFS began investigating both the father of the kids who perpetrated the abuse against Caitlin and Caitlin herself. Something that we often see is that DCFS will do emergency removals of children in cases where it believes that the non-offending parent might continue to have contact with an abusive partner. And in fact, DCFS's default presumption often seems to be that the non-offending parent will continue having contact with their abuser, and that any such contact is necessarily going to pose an imminent threat of harm to their kids, unless the survivor can clearly demonstrate that they have taken all steps necessary to cut off contact with their abuser. And that is an incredibly punitive standard to hold survivors to when they often live with and are financially dependent on their abusers, and they don't have the resources to simply up and leave on a moment's notice. So in Caitlin's case, almost immediately after the hotline call came in, the DCFS investigator asked her to consent to a safety plan, which is technically supposed to be a voluntary agreement done without any sort of court oversight or involvement, in which a parent agrees to a care plan temporarily for their children while DCFS investigates. So Caitlin agreed to have her kids stay with her mom for the time being. And at the time she reached out to our office, the terms of the safety plan required that her contact with the kids be supervised. So in Caitlin's case, our pre-petition advocacy strategy was to try to create conditions that would allow Caitlin to definitively separate from her abuser, and then also to convey to DCFS that the situation had stabilized, that there was no need for them to try to take protective custody. So how do we do that? We assisted Caitlin in obtaining an order of protection against her abuser, which gave her exclusive possession of the previously shared home. We reached out to the investigator and we advocated on Caitlin's behalf. We let the investigator know that this order of protection was in place and about all the other proactive steps that Caitlin was taking to keep her kids safe. We really emphasized that, things were under control, no kids were in harm's way, and that Caitlin was plugged in with supportive resources. We advocated that the safety plan be dropped and that the kids be allowed to return to Caitlin's care, which they were. The investigator did pressure Caitlin into accepting what are called intact services, which is a DCFS program that essentially allows the department to monitor families that they consider to be at risk by having a caseworker come out on a weekly or bi-weekly basis. Intact services are another mechanism by which DCFS surveils and regulates families, and it does put them under a microscope that frequently leads to them being screened into juvenile court down the line. So sometimes we will push back against an investigator who is trying to strong arm a parent into accepting intact services. For a variety of reasons, we didn't do that in Caitlin's case. Caitlin agreed to participate in intact services and she was successfully able to navigate the intact case. We advocated with the investigator that the allegation into Caitlin be unfounded. Technically, DCFS rules state that the survivor of domestic violence should be presumed not neglectful, but that presumption is frequently ignored. Fortunately, in this case, the investigator agreed to unfound the investigation against Caitlin in light of the many protective measures she had taken. And then finally, we collaborated with our housing practice group to assist Caitlin in preserving access to her housing choice voucher by invoking her rights under the Violence Against Women Act. VAWA protects survivors from losing their Section 8 housing voucher, even if their abusive partner was the original voucher head of household. So we were able to preserve Caitlin's access to her voucher through that. As a result of all this advocacy, Caitlin and her boys went from being on the brink of being screened into juvenile court and separated for months, if not years, to being stabilized and out of DCFS's crosshairs. Another example, we had a client who I will call Marcia. She was indicated by DCFS for environmental neglect because of substandard housing conditions in her home, even though they were not conditions that she was going to be able to fix herself. And she had actually complained to the landlord and then to CHA when the landlord didn't respond for years about these conditions. The landlord ended up filing a retaliatory eviction case against Marcia. So what did we do? We appealed the indicated finding of environmental neglect on Marcia's behalf. We actually lost at the administrative hearing, but we won when we sought further review through an administrative review action in Chancery Court. And our housing practice group, they successfully got Marcia's eviction case dismissed, and they assisted her in transferring to a new unit. So this is another example of how interdisciplinary pre-petition advocacy can stabilize a family and prevent things from spiraling into a crisis. And I want to put a plug in here briefly for pro bono opportunities in this space. Administrative expungement appeals and DCFS indicated findings, expungement appeals of indicated findings, and then the administrative review actions in cases where we are not successful at the administrative level are really great cases for pro bono involvement, because whereas a juvenile court case can be like a sprawling years-long ordeal, indicated report appeals and ARAs are time-limited undertakings. They present a discrete set of legal issues. So we are always looking to partner with folks willing to do these types of cases pro bono, and we would encourage you to reach out if this sounds at all interesting. All right, I think we want to read the CLE code one more time. If you missed it the first time around, it is 23SJ05. Again, 23SJ05. And then at this point, I'm gonna hand the reins back over to John.
Thanks, Delaney. We've had some issues with the chat and people being unable to find the link to the CLE credit. So my understanding is we're going to email everyone on the call here with that link, and that should solve the riddle here in a minute. So we'd like to share a number of ways you can help. They're on the screen. We could use your help as a volunteer or joining our ambassadors board. Our in-person luncheon is coming up in less than a month, and there's still time for firms and companies to sponsor this event. You can see that we've already got a robust set of sponsors lined up already. Any donation you make will help us continue the work for equal justice and ensure clients who need help with child welfare related issues receive the justice that they deserve. So that concludes the planned content portion of today's meeting. So in a moment, we'll start with the Q&A. When you do get the link, we'd appreciate it if you fill out a brief survey about the presentation, and that's forthcoming. Join us next week for our session on sponsored by our immigration team, which is just going to discuss the work of asylum seekers. So the panelists are going to remain to answer questions, which you should type into the Q&A. I see we have a few, including from one of our board members, Kenneth Carr. So Melissa, would you please take us through the Q&A?
Yes, absolutely. So the first question that I think I'll go ahead and answer, even though it's honestly a question that could launch a whole separate presentation. But the question is any entity or individual advocating a change in Illinois law to address the legal barriers? And I think the short answer to that question is yes, that there are always different forces at play trying to improve the system and improve the way the system interacts with families more specifically. But I do think that in recent years that there has been sort of a coalition of aligned organizations and offices that have developed, and that includes our office, it includes Ascend Justice, it includes Chicago Coalition for the Homeless, the Cook County Public Defender's Office, Shriver Center on Poverty and Law, ACLU, and we do try to coordinate together to talk about different strategies that can be taken to improve the way the system impacts our clients. Now, our office does not do any sort of legislative advocacy, so that is handled by other folks, including our subsidiary organization, Legal Action Chicago. So if there's any legislative change that might be explored, that is handled by Legal Action Chicago. But we're always trying to utilize each case in a way that can potentially improve the way the system responds to other families. And one example, that's also through individual case representation. When we're very selective in the juvenile court cases we take on, because when we do take on a case, we do tend to file unique motions. We try to take creative approaches in the law. We really try to push the case in a way that unfortunately the appointed attorneys or the attorneys who receive appointment don't have necessarily the bandwidth or resources to give that sort of attention to. And in that way, we're educating that judge in that courtroom about issues that maybe the judge hadn't been thinking about things in that way. So that's, you know, sort of a roundabout way of answering that question about whether there's, yes, we're always advocating for an improvement in the way the system treats our clients, for sure. And I think there are some really valuable partnerships that are moving forward. Another question is, in cases that are on the administrative track due to an appeal of an indicated report, is there a concern of bias because the administrative law judges are employed by DCFS? And I'm going to see if Delaney can answer that one.
So these indicated report appeals are handled in-house by DCFS. There is a department within the agency that employs administrative law judges whose job it is to adjudicate these indicated report appeals. The section of the agency where those administrative law judges are housed is walled off from everyone else. So they are not like interacting with or sharing information with, say, the department attorneys who are prosecuting the indicated report appeal finding. So they do take pains to separate the administrative law judges off to preserve objectivity and neutrality. That said, a lot of the administrative law judges did come up through the department. They might have started off as litigation attorneys within the department and then sort of were promoted or sent over to the administrative law judge section. So they tend to be experienced practitioners that came up within DCFS and sort of are well-versed and of the mindset that is typical of the department more generally, if that answers the question.
Sorry about that, had to find my mute button. Okay, another question is, does DCFS perform investigations of children in foster homes? And if so, do these investigations follow the same process for children in their biological or adoptive homes? This is actually something that CBS report Dan Savini explored a couple of months ago. Yes, they follow the same process, the same rules, the same body of administrative regulations and statutes apply for the administrative process of investigating an allegation of harm that occurs in a foster home, as would apply in a like the DCFS child protection investigation is the same in terms of form and function. But there was recent investigative reporting that revealed the investigations in foster homes were more likely to result in unfounded determinations as compared to biological families. I think there might be a lot of different conclusions we could maybe extrapolate from that data, but it is, you know, there was also a follow-up report that Dan Savini did for CBS Chicago regarding the experience of kids in foster homes and the number of placements that they often experience during the course of their stay in foster care. And another point that I thought about making during the presentation, but maybe dovetails here, is that for a person they were in the child welfare system as a child, when they become an adult, or even before they age out, if they themselves have a child, they are at an exponentially increased likelihood of then coming under the gaze of DCFS as a parent and having their relationship with their own child disrupted in some way. And so I think that also speaks to what is the experience. If we're removing kids from homes, from their biological homes, the assumption would be that we're placing them in better situations. But the fact is that the state is not a good parent. And what makes it even more difficult for the state to be an adequate parent is the fact that there are so many separations occurring that probably don't need to happen. The question, there was an NPR story a while ago about children being kept in foster care because their parents had not paid bills for the foster care. Does that happen in Illinois? I think it was either South or North Carolina that occurred.
North Carolina.
Thank you, Delaney. And I do remember that NPR story. And in fact, I remember Kate Shank, our deputy director, sharing that story with me in horror. No, that's not something that we've seen happen. What was happening, there was a trend a couple of years ago, now it seems to have stopped, is that the state, they would take protective custody, place the children in foster care, and then they would file a child support action against the parent, which of course just compounds the barriers and difficulties in terms of reuniting if the parent is having to fight the state on multiple fronts, especially since that parent was probably appointed an attorney, a free attorney in the juvenile court case due to being indigent. So that was a trend that was happening in Illinois, but I haven't seen that happening recently, thankfully, because that was troubling. Where there is an allegation of abuse, does legal aid objectively assess its validity and decline representation of a parent or withdraw from representation if the allegation appears to be valid? How does legal aid make that assessment? Delaney, how would you feel about taking this question?
Sure. We have a pretty extensive case acceptance process. When someone comes to us for an intake, we do an initial intake phone call, and we do a lot of follow-up, whether that's getting police reports through FOIA or interviews with witnesses, to really assess whether this is a case where we're going to be able to sort of make a positive difference. In a case where there are clear-cut allegations of abuse, it's unlikely that pre-petition advocacy from us or even in-court post-petition advocacy is going to result in like a reduction in harm for that family. So those don't tend to be the cases that we accept or that we prioritize. The vast majority of cases that we accept and the vast majority of cases that come through our doors in the first place for intake are neglect cases. That's reflective of the overall like volume of what the child welfare system is dealing with. And so in those neglect cases, there's rarely any sort of like maltreatment, intentional maltreatment of children. They are basically a function of poverty. And so in those types of cases, generally we do a lot of vetting and investigation before we accept a case for representation. But once we do, we are generally advocating for someone's poverty-related conditions to be recognized as not neglectful. That is just the lion's share of the work we do, and it tends not to be so much on the abuse side of things.
So I just want to acknowledge that we are about 4 minutes over the scheduled end. We understand if people need to hop off. We will be emailing to all participants the link for the CLE as follow-up. I'm not seeing any further questions in the chat, but we are happy to stay on and continue answering questions. Let me take another look to see if I've missed any. I'm not seeing any. It looks like we've addressed all questions.
Okay, I think thanks to my team for a fantastic presentation. Thanks to all of you for joining us. We'll email you the link so you can fill out the evaluation and get CLE credit. If you have any issues, just call our general information number and they'll get you to the right person. We'll see you next week and have a good day. Bye-bye.